Hi, my name is Attorney Angelo Pepa. We really wanted to give you some background as to what we were doing. When we started doing this project, it was amazing to us. Sometimes we were talking to children, sometimes we were talking to high school students, college students, other times we were talking to professionals in professional education, and it really became difficult. And so we think we finally arrived at a presentation format. First and foremost, we have a preliminary hearing on graduation day, which is a different day than the actual trial, which is consistent with due process of law and the various legal procedures. The second thing that happens is we have the actual trial with the children. We just did that, and we had them adjourned from here. Hopefully our cameraman someday will give you some footage of this opulent auditorium. It's amazing how gorgeous this place is in a day when Newcastle used to be a little bit different. But you know what, maybe the pride is still the same, and this is delivered with that type of heart. And we hope you receive it this way. So in this auditorium, we have already had the preliminary hearing, we have had the trial by jury with closing arguments, and now this message is for law students, for lawyers and CLEs and CMEs, and you'll notice all of the chairs are empty. We sent the children back to their lunch, and it would have been a little too taxing. But this is where we really want to get into the heavy lifting. And what's the heavy lifting? The heavy lifting is our collaboration between law, medicine, and education. And the heavy lifting is some of the ideas of each of these communities. I happen to have spent time in each one, and I'm really fortunate to have Judge Thomas J. Duerr, who is from Butler County, who's president judge, and he's retired now. But he was a juris juris. He's one of the youngest judges they probably ever had in Pennsylvania, certainly in Butler. And we want to talk about the fine points now of this law of DUI homicide by vehicle. And I'm going to turn it over to the judge, who's going to give a lawyer's perspective on some of these cutting issues. And then we're going to go to our special guest, Al Lindsay, who is the defense counsel, but he was also, him and his lovely wife, the producers of the entire trial by jury project. We are now to the point in time where we don't have the pressures of an audience with students, and we can now talk to lawyers. We can talk to legislators. We can talk to whether people who would maybe determine whether or not that law should be a law at all, much less how you would interpret it, as Al Lindsay has his own thoughts on that. So I'm just dying to hear, Judge Duerr, what you have to say about this law.
Well, the origins go back to the late 1970s and former Governor Richard Thornburg. So at the time, in Pennsylvania and the United States, there were approximately 90 deaths per 100,000 people per year as a result of drunk driving. In having lived through that, I can remember at the time my father talking about it, being concerned about his kids being on the road at night. There were actually more people dying as a result of car wrecks from drunk drivers than there were casualties in Vietnam. And Governor Thornburg formed a panel to consider what could be done about it. And the results were changing a section 3731, which was the drunk driving section at the time, reducing blood alcohol content for conviction from 0.15 to 0.10, and the addition of a new charge, homicide by vehicle while driving intoxicated.
So that actually became a law?
That actually became a law.
Signed by the governor, passed by both houses, et cetera.
Yeah.
So can I only interrupt you for purposes of making sure I got it straight? So we're 1990, approximately?
No, you're 10 years too late.
Okay.
We're 1981. The panel was formed, the law was enacted in 1982 and became effective in February of 1984.
And the blood alcohol limit's what?
Was 0.10 in the new law.
But we have a new law also. You can be, I'm sorry?
Charged with homicide by vehicle while driving intoxicated. The elements were first that you had to be convicted or of DUI, of driving under the influence, and second of all, that a death resulted as the direct result of the offense of driving under the influence. And
that's not a law that was in every state.
No, Pennsylvania was the first to have that type of law.
Anyway, I'm sorry to interrupt you.
Yeah,
Go ahead.
no, that's okay. So anyways, if you go back and you look at the progression over time, and there have since been modifications to the law, you can see that the deaths per 100,000 at the time, 90 per 100,000, have been reduced to today, they're approximately 30 per 100,000 people. And that is a significant reduction. That's a 2/3 reduction. And it has been brought about through legislation and education and just public awareness of the issue.
So back then, we were the only state, but there's probably more states that have it now.
Oh, yeah, there are
Okay.
more states
I'm
that
sorry.
have it now. So, again, the element is that the death resulted as a result of the driving under the influence. Now, you can imagine at the time that there were challenges to the new law, and one of the cases involved the issue of causation, and was the drunk driving the cause of the death of the other person. So there.
May I interject here?
Yeah.
To pull our movie in, a little hypothetical.
Yeah.
Jake looks over as his girlfriend says something to him and aims a camera at him, or Jake did that because he was under the influence. That's what we're talking about, the causation in a real elementary way.
In an elementary way, that's correct. And the original language was a direct result. And they have since changed that by an amendment that came about, I believe it was 1996, where the word direct result was eliminated, and it now says as a result.
Question.
Yes.
Okay. So it sounds like direct was the legislature's attempt to make it a little bit difficult to convict somebody of that because it was a little more penalty, I would think. And so when they took the word direct away, it seemed like they were making it easier for a prosecutor. Am I interpreting that right?
You are interpreting it correctly.
Thank you.
So in the case I've talked to you about before that I was involved
And you were involved as a lawyer in the case.
as a lawyer before I became a judge, was a gentleman who was driving down a highway. There were witnesses who were following him and testified that he wasn't weaving, he wasn't driving over the speed limit, and as he approached an intersection, the light cycled through to yellow, and he actually went through just moments after it cycled to red. And there was a vehicle coming the other way that went through the intersection, and they timed entering the intersection anticipating that the light would turn green. You know, you can see the reflections of the lights when you do that. So the defendant's vehicle impacted the side of the other vehicle. The occupants were ejected from the vehicle, and both of them were killed. So the defense was that this gentleman that survived, that was driving the van that struck the other vehicle, wasn't exhibiting any signs in his driving of driving under the influence, that what happened was he did what many people do, tried to time the light, and he just mistimed it. It went to a jury trial. The jury found him guilty of driving under the influence. Again, as in the trial that we saw in the video, there wasn't really any question because of his blood alcohol reading.
So element number one's made.
Element number one, element number two, it was stipulated that there were two people who died as a result of the accident.
Okay.
The issue was the causation.
Causation.
And the jury deliberated for quite a while and returned a verdict of not guilty in the case.
And again, the not guilty would be that although he was drunk, that wasn't the cause. And in the old law, it would have been the direct cause. But now it's no longer the direct cause. It could have been the cause.
Yes.
Not the direct cause. Yeah. So that was a jury question. And it sounds like justice was done.
Well,
Were you the defense attorney?
I was, the defense attorney was Mike Mamula. I was second chair for the defense in the case.
Mr. Lindsay knows this guy too.
Mr.
Probably.
Lindsay knows him very well.
Okay.
And had tried many cases against Mr. Mamula when Mr. Lindsay was a DA and Mr. Mamula was the defense attorney.
And you were with the defense team?
On that case,
Okay.
yes. So it depends on which side you talk to as to who believes that justice was done. The judge in the case was upset with the jury and gave the defendant a maximum sentence for the DUI of 1 to 2 years. I spoke with the jurors afterwards. After a trial, they're allowed to speak with the judge or any of the witnesses or the attorneys, and they felt that there wasn't sufficient evidence that his drunk driving was the direct cause of the accident, that he was simply trying to time the light and mistimed.
Question. So is that the status of this law today?
No.
So it changes again, right?
Yeah, the word direct has been eliminated. Other than that, the law is substantially the same.
Now, I'm sorry to interrupt you again,
Yeah.
but I want to make sure I keep it on point with our movie here. The difference in him being convicted of that and him being convicted of DUI is literally mandatory jail time, correct?
Of 3 to 6 years for homicide by vehicle.
So regardless of the age of this, well, if they tried him as a juvenile, it would be different. But if
Correct.
they tried him as an adult, our defendant in the wheelchair
Yes,
would go mandatory 3 years in jail.
yes. And in Pennsylvania, a minimum has to be 1/2 or less than the maximum. So the minimum sentence is actually 3 to 6 years.
So he'll definitely be in jail for 3 years.
Yes.
Wow.
Now, and since then, the law has been amended. If you have a prior conviction for DUI in Pennsylvania, it ups the minimum sentence to 5 years, and if you have 2 or more priors, it ups the minimum to 7 years. In addition, it's now mandatory that for every decedent, every victim, there has to be a consecutive sentence. So if there were 2 people in the vehicle who were killed and it was a first-time offender, it would be 6 to 12 years. Or if you had a prior DUI and there were 2 victims, it would be 10 to 20 years.
And only for the purpose of our viewers, can I ask you a question? Consecutive sentence means that the judge could otherwise sentence somebody to 2 different counts concurrently so that they would serve the same thing, but the law now doesn't allow that and makes you stack those on top of each other. Am I saying that right?
You are saying that correctly, and that would be specific to the 3735.
So let's go back to your hypothetical. The jury found the other way,
Yes.
that it was a cause. And there were 3 people in that car that all died.
Under the current law, it would be 3 years times 3, which is 9, so it would be a minimum sentence of 9 to 18 years consecutive.
Not concurrent.
Yeah, under the prior law, it would have been 3 to 6 years as the minimum mandatory. The judge could have a discretion if he found sufficient cause. He would have to state on the record for making a sentence consecutive.
One of our sponsors to our program, who we're really excited, is Marla Brown. She's a brand new representative in District 9. And Marla couldn't be here because she's in session. But Marla, we have the preliminary hearing, we have the trial, and then we have this shooting session after the trial. All of it because of Dawn Goodland's available online in perpetuity. But Marla is going to have a community symposium of educators, lawyers, and doctors. And this question would go right back to Marla. You're a lawmaker now. Maybe you should be listening to some of this. Should this be the law? Always comes into play, too, when it comes to the House of Representatives. And so we heard the judge talk about that. There's always that issue of what is the law? How is it determined to be applicable? But now, should it be a law at all? Do you have an opinion on that?
I think it's been a very good law. It's been a very effective law. The Supreme Court in Pennsylvania has held that the law was a constitutional law. It was challenged in many ways in the beginning. And an oversimplification of what the Supreme Court has stated is that it's the prerogative of the legislature to determine what is a crime and what is an appropriate sentence for a crime in enacting a minimum mandatory. Procedurally, they can't tell the court system what to do. but substantively, it's their obligation, and it's their obligation and right under the Constitution to do so.
And again, I want to turn this into a civics lesson, but the legislators have the right to conduct hearings about attitudes and things like that. Those kind of things come into play. That's why they got elected.
Yeah,
and that's their competency.
Yeah, and I talked in the beginning about reducing the number of deaths from 90 per 100,000 to 30. It's been a significant reduction. There's still room for more. One of the considerations now, and Mr. Lindsay and I had talked about this just a while ago, was that the immediacy of the consequences is so important. And so how this would come up is it's been proposed that if somebody is arrested and fails the intoxilizer test or refuses to take it, that the police have the authority to immediately confiscate the driver's license. And it's that immediate ability by the police, which is going, in my mind, to have a bigger consequence as a deterrent than the severity of the punishment down the road. It's how soon you suffer some consequences. Another area where that would be important is when you find people who are in crisis with addiction. They don't always have a moment where they've made up their mind to accomplish some kind of a change. And they can get 1 or 2 offenses, sometimes even 3 offenses before they're brought into the court system, because as you know from the preliminary hearing, it takes a while to get in. So if the license would be immediately confiscated, it would be an immediate consequence. And it can be legal. If there's a problem with the confiscation, you can establish a right to a judicial review.
And let me go on your side of that. Not only is it an immediate, we all learned this from teaching public school. The punishment should be quick and effective to teach the child what not to do.
Yes.
But aside from that, you take the modality of the harm away, the weapon away from the guy immediately too, because somebody that's out in wide open addiction or having a bad time of it in alcohol or whatever, taking that car away from him is going to save more lives rather than just punish him.
Well, it's not taking the car, it's taking the license. There's
Which
still
takes
going
the
to be,
car.
right.
Yeah.
There's still going to be people who drive without a license, but
Fewer.
yeah, you can't look for 100% compliance as a reason not to enact a law. You have to do what there's going to be substantial compliance.
Do you see that coming?
I don't know. That's something that we can talk about when we meet with the legislators.
Interesting. Okay, Judge, just to make sure we don't have any confusion, the current state of the DUI law as of today.
Well, the current state was enacted in 2004, and it lowered the blood alcohol content to 0.08. And also for minors, 0.02. So if a minor has any alcohol in his system, it's DUI.
And that's 2008.
That's 2004.
2004, okay.
0.08.
Okay, and it's 0.08,
Yes.
adults
And 0.02 for minors.
for minors.
Yep.
Okay, and so other than that, the DUI, the homicide by vehicle, is as we've discussed.
Yeah, it was amended in last time 1996 has remained that way since.
And the word direct is eliminated.
The word direct has been eliminated.
So it's cause.
Caused the death as a result of the DUI.
Thank you so much. Okay, Jim.
Okay, the food's here now.